Leno? Hey, Pat. I've already dictated you a letter with the new offer.
Oh, hot dog.
Yeah, and I saved everybody's seat.
Oh, shoot.
I saved everybody's
Yeah,
Yeah, I know. I've got 2 more seats for you.
well, you know, the odds. I wanted to make sure we all had.
You all disappeared.
I was telling Kyle the first time I came in. The general there, and a couple of days, and they go out. I'm sitting right in the board.
All right, so good afternoon, everybody. Thanks for coming. So it's around this time of year, within about a month or so before July 1, that WICLA kind of does a year-end review of our MCLE program, because as of July 1, we have to recertify with the MCLE board. So in that regard, if there are any questions or any suggestions or any comments that you, the members, have about how we can improve this program, how we can improve the online aspect of this program, how we can improve the paperless aspect of this program, which we're trying to do this year, please let us know, because this is a critical period of time when we are recertifying to the MCLE board. After July 1, we really don't care very much about what you say. We're recertifying. I'll leave it in court. But right now we care a lot. So please, any comments or any suggestions you have, let us know. Are there any other announcements that I need to make? Any YLS events coming up?
Next happy hour is going to be April 27th at Joy District. Emails will be coming soon.
What was the date on that?
27th. April 27th.
April passed.
April? Oh, June.
So the next YLS event is June 27th. I believe there was a YLS event last week, cigar tasting and whiskey tasting. Did anybody go to that? Great. How was it? So, I did, from what the reports I heard back, it was a really great event. So those YLS events are really great. They go to some of the most, hopping joints in the city. So please participate in those YLS events if you can. Any other questions or comments or concerns about membership issues or MCLE issues or YLS issues? All right, great. So the program that we have today is titled The Rebirth of TTE, which everybody knows is temporary transitional employment. And we're specifically going to be talking about this case called Stegan versus Relodyne, which is a recent Workers' Compensation Commission decision decided in April of this year, and in the 4 or 6 weeks since the case has been decided, there has been a lot of talk about this case and what it means and what it says and what it requires. So I wanted to make sure that we got this to the membership as soon as we possibly could. We are very lucky today to have the 2 lawyers who handled this case here to be talking about the case. Andrew Kriegel, who represented the petitioner in this matter, and Jason Kolecki, who represented the respondent. So the format of this program today is going to be, I'm just going to run through some of the preliminaries, take you through what the case held, and then we're going to bring Jason up first so that he can give 5 or 10 minutes worth of comments. We're going to bring Andrew up next so that he can give 5 or 10 minutes worth of comments, and then we're going to open it up to questions, and I'm sure there's going to be a lot of questions regarding this case, what exactly it means, and as I said, what it requires both petitioners and respondents to do in these quote-unquote TTE types of programs. Okay? Any questions about that? Everybody understands the scope of what we're going to be talking about today? All right, good. So You know, we always start off with interstate scaffolding when we're talking about TTE issues, because interstate scaffolding tells us that the determinative question, the conclusive question when you're dealing with TTE issues is this idea of maximum medical improvement, or as the Supreme Court called it in interstate scaffolding, stabilization, right? So that's the determinative or conclusive question when you're dealing with whether a petitioner is entitled to ongoing TTE benefits. Except, of course, as the Supreme Court tells us, when it falls into one of the 2 or 3 exceptions to that rule about MMI or stabilization. And one of the exceptions to that rule is the exception that applies to the Stegan versus Reladon case. And the exception to this rule of conclusiveness or determination based on MMI is this idea of offer of accommodated employment, right? So when, as we all know, when the respondent, when the employer offers accommodated employment and the petitioner refuses to do the accommodated or light duty or restricted employment, whatever you want to call it, that's an exception to the interstate scaffolding rule. You're no longer just looking at whether the petitioner has reached MMI or whether the petitioner has gone into some kind of status of stabilization. You're looking at this idea of whether that there was this offer of accommodated or light duty employment. Which brings us to the issue of TTE. So as you who have been attending these programs for the last several years know, here in these programs, we've been talking about TTE for a long time. You know, 4 or 5 years ago, we first began our discussions about these TTE programs. And here are some of the cases that we talked about way back in August of 2015. So we talked about cases like Lee, which you're going to see cited in the Stegan decision. We talked about some of these other cases which generally dealt with this issue of temporary transitional employment. And the reason why this program is titled The Rebirth of TTE is that people, especially people like me, were pretty sure that TTE was dead, right? That there was no such thing as TTE. Why do I say that so strongly? Well, because this Lee case, which was one of the first cases that talked about this, said that. It said there is no such thing as TTE. There's no such thing authorized under the Act. There's no such thing contemplated under the Act. There's no such thing in the Act or in the rules or regulations of the Workers' Compensation Commission. So these cases are cited just because I wanted everybody here to know that we've been talking about TTE for a long time, and why we titled this program Rebirth of TTE, because we were pretty sure after these cases came down, at least a person like me, I was pretty sure that TTE was dead. Lo and behold, a case comes up which shows that it may or may not be dead, depending on your perspective. And this is the Stagen case. I was saying Stegan, I'm sorry, it's Stagen, S-T-A-G-E-N, versus Reladon. So, in this case, before the arbitrator, you can look at the decision which I've given you there in your written materials. The only contested issue in this case, and I'm sure the lawyers will talk about the procedural aspect of that in a second, but the only contested issue in this case was whether the petitioner was entitled to ongoing TTE benefits, because there had been one of these kinds of TTE or accommodated work offers, and the petitioner had refused to engage in that type of work. So the only contested issue in this case was the entitlement to ongoing TTE benefits. Apparently, and the lawyers will tell you more about this, the restrictions in this case were not disputed. If I'm remembering the facts correctly, Mr. Stagen was a forklift operator, and clearly whatever restrictions he had prevented him from returning to work for the respondent as a forklift operator. He was offered and I'll let the lawyers tell you about how that offer came to be. He was offered a position at Northern Fox Valley Habitat for Humanity, a position that arguably met with the restrictions that he had. Notice that Northern Fox Valley Habitat for Humanity is not his employer. His employer is Relodyne LLC. There was some testimony in the case by a woman who is the president of an organization called Transitional Work Solutions. Her name is Dina Snyder. She testified about this program, how it worked, how the offer came to be. The arbitrator specifically in her decision noted that the petitioner was not employed by Habitat, that the petitioner's employer was Relodyne. The arbitrator specifically said that she thought that this was not the equivalent of an offer of light duty or accommodated duty. It was different somehow from just a standard offer by the employer of light duty. And on that basis, citing cases like Sanity, Kilduff is the name of that case, and Lee versus Fluid Management, that initial case, the arbitrator decided that temporary total disability benefits should not be cut off because the petitioner was within his rights to refuse this offer of temporary transitional employment. So the case goes to the Workers' Compensation Commission, and the Workers' Compensation Commission reverses the arbitrator's decision and cuts off the TTE benefits as of the date that the petitioner refused to take that accommodated job with Habitat. So here's what was significant to the commission. From what I can tell from the decision, I'm sure the lawyers will tell you more about what they think is significant. So clearly the respondent, Relodyne, engaged this company called Transitional Work Solutions to enroll the petitioner in this TTE program. That the commission found that. The petitioner chose not to participate in the TTE program. I think that was probably stipulated to. It's not like he showed up and there was some confusion about whether he should have been there or anything, right? He refused to do that. According to the commission, the petitioner offered no explanation for why he did not show up for that TTE, but then again, he won his case in front of the arbitrator, so at least as far as the arbitrator was concerned, there was no explanation necessary. The commission found it extremely important that the petitioner was saying that Habitat was not his employer. So how could it be an offer of light duty employment if Habitat was not his employer? And what the commission says is that that's a distinction without a difference. And why does the commission say that it's a distinction without a difference? Apparently because if you look at the circumstances of the case, the commission finds that the petitioner was still and always an employee of Relodyne. Right? He was being paid when his offer was made. The offer was that he would be paid his regular pay, not TTD, not TPD, right? His regular pay from the respondent Relodyne. He wasn't going to be paid by Habitat. He wasn't going to be paid by some third party like an insurance company or an adjusting company. He was going to receive his regular, quote unquote, regular salary from his employer, Relodyne. According to the commission, what was extremely important was that the petitioner remained, quote, subject to respondent's human resources and attendance policies. The respondent's human resources and attendance policies, right? Not the policies of Habitat. Clearly, he remained an employee of Relodyne during this period of time when he was being offered work at Habitat. The commission said that it could not be inferred from any of these circumstances that the petitioner was no longer working for the respondent, right? That what this essentially, and this is my opinion coming in, essentially what this ended up being, according to the commission, was an offer of light duty employment by the respondent. It happened to be off-site at another location, but it was an offer of light-duty work by the respondent. Petitioners claim to be entitled to continue TTE simply because the offered light duty is not with the respondent, does not comport with the remedial purpose of the act. So what the petitioner argued was, look, this is a remedial act. I'm being offered something not by my employer, by some other third party, and the commission says, no, this is an offer of light duty. It's the equivalent. Remember, the arbitrator said this is not the equivalent of an offer of light duty. What the commission seems to be saying is, yes, it is. It's the equivalent of an offer of light duty, and therefore terminates the TTE benefit as of the date of this offer of light duty with this company called Habitat, or this charity called Habitat. Now, I'm going to ask Jason to come on up here and tell me why I was wrong about how I summarized this case. And he's going to do that for about 5 or 10 minutes, and then Andy's going to come up here and do that, and then we'll open it up to questions, okay?
Thank you, Dave. Once again, for those of you that don't know me, my name is Jason Galecki. I'm with Tennessee Roach, and I tried this case with Andrew and represent the respondent. Just a little background on this. This Relodyne is a East Coast employer primarily, and when I got the case, they told me that they offered this position and it was being refused. They were flabbergasted. They could not believe it. They're like, East Coast, we do this all the time, there's no issues. I can't understand why. And I went through some of the cases that we've cited here today that have been talked about, and more or less that Illinois was not on board with that yet. The decisions prior indicated the statute did not allow for that. Well, they wanted to change that. So they gave me the authority to proceed ahead. Procedurally-wise, we did do it under a reverse 19B. So the petitioner was paid all his benefits during the period of time up to the date of hearing, and actually through the date of the decision. Eventually he returned full duty, so that's an issue of its own. But for the purposes of the hearing, everything was paid up to the date of decision. That was one of the reasons we were able to streamline this and make the issue of transitional employment so the main focus. And that was partly what I wanted to do, because if you look at the decisions that came before this one, there's other issues that get in the way. There's issues, was the offer legitimate? Did they cut them off? Was there TTD? Was the restrictions the same as the IME doctors? This was not the case. This was a situation where the doctor that the petitioner was treating with provided restrictions, the job offer was within the restrictions, there was no dispute from the respondent's point of view. There was no reason this gentleman should not have taken that position. As indicated, there was no offer explained at the time of hearing, as cited by the commission. Now, throughout this term, temporary transitional employment, I'm not sure where it came from. I consider this light duty. I always have. Most people that say, well, it's not, there's no authority under the statute for transitional temporary employment, I would agree with you. You won't find that word anywhere in the statute, in the act. But I don't consider this transitional temporary employment. This is a light duty offer. One of the things I did point out in my oral argument and in my brief is if you look under Section 8A of the Act, where it talks about temporary partial disability, which we all know what that is. It's 2/3 the difference compared to TTE. But it does talk about, and I can specifically indicate, when an employee is working light duty on a part-time basis or a full-time basis and earns less than he or she would be earning if employed in the full capacity of the jobs, then the employee shall be entitled to temporary partial disability. None of that states it has to be with the employer. There's no specific indication that it has to be within the employer. And we're not talking about maintenance. Some of the cases up there that are discussed are when a person reaches maximum medical improvement. This is not the situation. This is a person that was temporary, totally disabled from a standpoint of could not return to his full duty, but obviously he was physically capable of doing something. So temporary partial disability contemplates the possibility that you're entitled to 2/3 if you're working for your employer or some other job, and temporary partial disability only pertains prior to MMI, then why should there be a difference with temporary total disability? And how can we state that the Act does not contemplate that? If it contemplates it under TPD, why would it not consider it under TTD? So that's one of the arguments that I tried to put forward, and it seems like the Illinois Workers' Compensation Commission agreed with it. It was a three commission decision vote in favor of who responded on this issue. One of the questions I also come up with, and some of my petitioner brethren can respond to me, I don't see how this is so scary. It's a light duty job offered within the employee's restrictions. This is not a dispute, an IME versus doctor's restrictions. This is the treating doctor saying, you can do this, and somebody saying, we have a job for you, you're going to be paid your full wages, you remain an employee. I'm not sure why there's this huge uproar about it. Chuck?
Yeah, I think there's a couple things. First of all,
Sean, can we
Yeah, I'll wait.
let's
I
handle
thought you
it.
were soliciting that.
Good, thanks.
No, I was just putting that out knowing that it's coming, but no problem. So that's one of the things that I look at this for. And I also, when I argue this and I look at this, and people say, well, it's not contemplated under the Act. What about the loaning and borrowing portion of the Act? How is this any different? Section 1 of the Act talks about it, that you can loan somebody and they're still covered if they're an employee, and if not, there's ramifications. So if another injury does occur while they're doing this other position, there are ways to obtain benefits, file a new claim, who's going to be insured. So I do think that this type of offer of light duty, in my opinion, I don't like the word temporary transitional employment, because one, I agree with you, you're not going to find it anywhere in the Act. There's a lot of things you're not going to find in the Act that are derived out of case law, but you're specifically not going to find this in the Act. One other thing you're not going to find in the Act is the definition of light duty. There's no specific definition in the Illinois Workers' Compensation Act that says this is what light duty is. It doesn't. So we have to work with how the facts present themselves and then how the case law comes out with respect to positions. Thank you.
Hi, I'm Andrew Krischel. I tried this case with Jason. You've heard the procedural background. This was a worker for Relodyne. He suffered a bicep tendon tear that's not disputed. He receives a letter from his employer, Relodyne, advising him of a position at the Northern Fox Valley Habitat for Humanity. Asks him to check in with the volunteer coordinator for the Northern Fox Valley Habitat for Humanity. And there's an orientation meeting with the volunteer coordinator, and a start time at the Northern Fox Valley Habitat for Humanity was pending that orientation meeting. One, I think the arbitrator had her decision correct. There is no temporary transitional employment under the Act, and I think that's what this was. The fact that they say this was a light-duty job offer, I don't believe that there's any basis for this to be a good faith light-duty job offer. The job offer was solicited through a company called Transitional Work Solutions. There was testimony from Dina Snyder, the president of that company, who testified that her company is hired to find positions with other entities when an employer cannot accommodate restrictions for an employee. Dina Snyder, who found this position with the Northern Fox Valley Habitat for Humanity, had no knowledge of petitioner's work restrictions other than what she had received from Relodyne through a third party. She had never been to the Northern Fox Valley Habitat for Humanity and had no knowledge of what the job entailed other than what she had received from the volunteer coordinator during a phone call. So based on the clear language of the Act, there's no temporary transitional employment, which is what was argued and what the arbitrator, I believe, rightly ruled. And reading the commission decision, it almost seems like they treated this as a light-duty job offer, but given those facts, I don't see any basis, any good faith basis to consider this a light-duty job offer, being that the person who found the job had no knowledge of the petitioner's work restrictions, and there was no testimony from any other Relodyne employees or employees from the Northern Fox Valley Habitat for Humanity as to whether this job would comply with petitioner's restrictions.
All right, let's open, come on, let's open it up for questions. Yes, sir. Is this going on?
Yes, it is. I think we're up next week.
Monday's case management conference in front of the circuit court, yes. John, do you want to go ahead with your?
Well, yeah, I just wanted to address the, I think what you were asking about what the fear is. I mean, I think there's a couple of different things. First of all, you know, whenever we choose to go to work for somebody, it's a mutual decision, right? I apply for the job and the employer hires me, okay? I didn't apply to work there, so there isn't a relationship between those two entities anymore. In other words, I mean, the Act is written about employers and employees, and the relationship between the two of them. You're taking an outside person, you're putting them in there, and I think the reason why you may have been successful isn't because there's nothing wrong with sending them elsewhere. It's sort of the way Dave phrased it, which is that maybe because they actually treated this as, I don't know, you know, a field trip with the employer. So everything was exactly the same except for doing a job at a different location. I think maybe in that circumstance there's an argument to be made. But I guess my question was, what happens if the charity or this situation is objectionable to the petition? In other words, what if it's Planned Parenthood and the petitioner says, I don't want to work at Planned Parenthood, I have an objection to that? Or what if it's, you know, I don't know, something else where there's a legitimate objection to working at this charity? That's where you see the conflict of the employer-employee relationship, you know, coming up. In other words, you know, I choose to work here because I don't have a political objection to working where I do. Or, you know, you see what I'm saying?
I do, and just to respond in two things. Sean actually indicated when you take a job, there's a mutual understanding. But you're also taking a job to be a truck driver, to be a forklift driver. What happens if you have a light duty and Relodyne and says, you know what, you're going to sit in that room and count widgets? Was that what you wanted to do? No. But guess what? You have to do it now. Whether they're objectionable to it or not.
Still furthers the purpose of the respondent.
Oh, hey, can we?
Hold on, we'll get to you. So I do understand that, but I mean, things aren't going to always work out. And with regards to the Planned Parenthood issue, I honestly don't know. I can't respond, but I wouldn't think that would come up very often.
Yeah,
Morgan's
I'm
office
just
has
saying,
that now.
We have
For
that in a couple
example,
of cases.
if there was an objection, and then also the fact that they paid him, I'm assuming this fact to be accurate, exactly what he or she was earning, that has a big deal because a lot of times these offers are, we'll pay you $10 an hour and you're going to get TPD for the difference. I think that is...
That could be, yes.
I mean, that's an important fact.
Based on my discussion with the commissioner during oral arguments, based
that's
on
what
the
we
decision,
talk about.
that it was something that, yes, he was going to be paid his full salary. So it was almost beneficial for him to go back to work.
And in fact, take a look at the decision. There's a discussion about that. Right? I mean, there's a discussion about, you know, what somebody should take a job that could pay them more than they
Well, I think it's completely irrelevant whether the commission thinks someone should take a job. The employee never bargained to work for the Habitat for Humanity. It creates an indentured servitude almost, forcing someone to go to an employer or an organization that they did not agree to work for. That's completely different than light duty work counting widgets, as Jason explained when someone's hurt on the job. For the employer, this is a company that has nothing to do with the Fox Valley Habitat for Humanity, and they're sending a worker there. If you're a contractor, you don't have to perform work for someone you don't like or that you choose not to, so there should be nothing that forces an employee to go work for a company that he did not bargain to work for.
So
This is what I love, right? We've apparently hit a nerve here. And this is great. But can we all be respectful to that and just try and condense a question, you know, so that everybody, as many people as want to speak can speak? So, yes, Commissioner.
I think it's
Can't hear,
clear.
whoa.
Couldn't hear anything.
Repeat, could you just paraphrase the question?
The question was whether petitioner understood that he would be working for an entity other than the respondent.
Right, because the decision, the commission specifically says, no claim or evidence was advanced by petitioner that he understood his employer to be any entity other than the respondent. So I would ask the counsel, do you feel that you presented any evidence to the contrary?
Yes, I do. Yes, I do, Commissioner. The questioning of the petitioner notes that he would be working at Northern Fox Valley Habitat for Humanity Resource. He answered yes. And that obviously this was not his employer. He answered yes. Reladon is my employer. So I think it's clear that petitioner knew he would be working for Northern Fox Valley, which is not his employer, and that Reladon was his employer.
Yes, Ken.
Jason,
Yes, sir.
did you hire this transitional workplace or did the employer already hire them before they ever contacted you?
Before I even got this case, they were already on the file.
Are you the one who told them to give them full salary?
No, that was offered before I was, like, everything was done. I got the case when Mr. Kreigels, the petitioner, rejected the offer.
When they offered the job to him, did they also say, if you get hurt at this other place, we're going to cover any of your work injuries at this new employer?
I believe there was testimony to that, but I don't believe that was actually in the offer. I think it was, in the offer was you would remain an employee of Reladine and all your benefits and rules and human resources policies would be under Reladine.
This transitional place, obviously since there's no TTE in Illinois, where is this company out of that this woman testified, Steve Snyder?
It's an East Coast company. I believe she was stationed out of Georgia, but in Illinois they also have a reemployability that has offices here, and I think Dina Schneider, this Transitional Work Solutions, also has an office here. But I think they're based, Transitional Work Solutions I know is based out of Georgia.
So when she's testifying, according to the arbitrator in the decision, she said that the individual did not even know about his work requirements at this Habitat for Humanity. So if she doesn't know what the job duties are, or if the guy's going to be capable of doing it, then how can she say it's a suitable employment for him when she's never doesn't even know the job duties?
I don't believe that's accurate, Ken.
So you're saying the arbitrator's decision is wrong?
Yes, obviously it was, because the commission reversed it. No. But what I'm saying is what Mr. Kreigel talked about with Ms. Schneider not knowing the job restrictions. There was no dispute regarding the restrictions. These were the treating doctor's restrictions, and there was no dispute the offer that was provided was within those restrictions.
No, that's not what it says.
I disagree.
The arbitrator's decision says Ms. Snyder testified she had no personal knowledge of the job requirements associated with the volunteer position. So if she doesn't know the job requirements, even though the employer has told her what the restrictions are, then how can she say this is suitable employment? Did Andrew go into that at the time of the hearing?
So I don't think that's what this case was about, right? This case wasn't about whether this job met his restrictions. Right?
Well, no, that's what they made it. Well, but if you're defending the case or you're the petitioner, aren't you going to attack the company that's been hired to try and say this is not suitable employment or you don't know anything,
Well,
or if you're angry, you say, why didn't you take this guy and have him try the job and set it up for a 19B to say this is not suitable, but you don't want the guy getting cut off, so you have to take the job.
The commission found that it was a bona fide offer of light duty, right? Right there, simply because the offer of light duty, right? So it wasn't a matter of whether the offered light duty was within his restrictions, right? This was a bona fide offer of light duty, right? So that
Well, you attack it different ways.
well, of course it was. Except if you believe that TTE does not exist, right? Then you
But
fight
you
it
never
out.
assume that.
Well, the case law
I don't know why
was
we wouldn't have
clear that TTE didn't exist. Respondent filed a reverse 19B and continued to pay petitioner. There was a favorable ruling, and there was testimony elicited to attack the job offer, which the arbitrator noted, stating that the person who offered this job had no idea what the requirements were and whether it fell within the restrictions.
Ken, just in response, I think that's a little armchair quarterback with after the fact how Andrew would have argued, how I would have argued. But in the end, I don't think it makes a difference because that issue wasn't in dispute. There was no dispute. The offer was made within the restrictions. Who cares if Tina Schneider knew what the job was and what it entailed? As long as it was within the restrictions, it's light duty. Am I wrong?
Yes.
Yes.
I am? Yes. Okay.
Okay.
Let's assume in your favor that this is a bona fide job offer.
Well, it was, because the commission said it was.
Let me finish my syllogism.
Sure.
Let's assume that this is a Volk situation. They place him in this. The first red flag is temporary transitional employment. Every case that I'm aware of with regard to accommodated employment and a stranger to the respondent says it must be in a stable labor market. It must be a full-time permanent job.
Okay.
The very title of this company's name is, it's temporary.
Okay.
Number two, was this a paid job at Habitat for Humanity?
Relodyne paid him a salary.
That's not what I said. Did the company, Humanity, Habitat for Humanity, have a paid position that allowed the petitioner to know that at least he had a job that was there, it wasn't created, he's going to make $10 an hour or whatever it is, and that's where he's going to work because it fits his restriction? I'm assuming there was no pay by Habitat for
Can I
Humanity.
answer?
Yeah.
First of all, we're not talking about vocational rehabilitation. So this is, you're off the track. This
No,
is
I'm not.
Wait, let me finish, Rich. Let me finish. This is not MMI. He's looking for a job within his restrictions. This is, I haven't reached MMI yet. I have not been placed at MMI yet. I have light duty restrictions. Do you have a job for me?
No, that's incorrect because your logic assumes that, as Andy just pointed out, this guy is nothing more than an indentured servant. And because the insurance company or the self-insured people don't want to do this, they set this guy up right, didn't they? They're going to pay him $20 an hour to go to Habitat for Humanity without any information as to what he's going to be doing. It's a temporary job.
Correct.
So it's simply the philosophy that it's better than him sitting on his butt at home watching Judge Judy get him to do something even though he can't control it. I mean, as a matter of law, this is going to be reversed.
Okay. I mean, first of all,
as a matter of law.
If it's that easy, then I don't know how I won 3-0, Rich, but you're an expert.
I got $100 in my pocket and I'm really
In the front. Yes.
You draw the distinction, following up on Sean's comment.
Sure.
I have a bunch of cases where they send their people to Habitat for Humanity. They're going to pay you $10 an hour, and we're going to pay you the difference in TTD. Is that distinction, do you draw that distinction?
Absolutely.
Right.
I think, and I don't know if personally I do, but I say based on that decision, the way they pointed out that he was going to get his full salary, and the meaning of the act is to make sure somebody's getting their benefits back to where they were before they were injured, I think that is a big distinction based upon this case law.
So that would be TTE then, if they paid him $10 an hour and a difference.
Where did this
word TTE
I
come
don't know,
from?
but where did MMI come in? MMI is not the statute.
Exactly, I'm not sure. So like I said, I don't consider this TTE, I consider it light duty.
But you would, as a response attorney, you would find a distinction.
I would advise my client there is a distinction. In the back, you've been waiting a while.
Yeah, so actually it's following up on that topic. If we're talking about a temporary placement while he's still treating, and we're talking about TPD pay, wouldn't he be owed not his salary, but what his wage would have been had he been able to return to work? Because TPD is phrased the same way as maintenance. It's not based on average weekly wage. So would this guy have owed any increases he would have been due? I mean, everybody's been saying salary, but people are mentioning hourly. So right off the bat, was this guy supposed to be hourly in his original job? And two, wouldn't the respondent have owed increases that he would have accumulated in his time off?
Well, he was, I think, an hourly rate of $13 an hour, Andrew. Something we started,
$25, give or take.
Yeah, I can't remember exactly what his rate was.
Yeah.
Once again, when I referenced the TPD issue, I only referenced that to indicate that it's contemplated under the Act, not only employers, but other employers. And the commission specifically says that one of the critical factors was that the petitioner remained, quote, subject to respondents' human resources policies, right?
So he'd had a salary increase.
Raises are part of their human resources policy.
Okay, so the payment would have to be per those policies according to this. Okay.
Hey, accrual of vacation time. Everything else, 401k contributions, right? Everything else that comes with being subject to respondents' human resources and attendance policies.
You think fringe benefits, Dave? If it was a union worker, you think that would go all the way?
Subject to respondents' human resources and attendance policies.
Okay.
So there's facts missing here that might have changed the dynamic of how this went. Did the petitioner receive a letter in the mail?
Yes. Yes.
And were the hours the same or similar as he was working?
Yes.
And was the distance to the place within reason?
Yes.
Okay, so he didn't go to the orientation is what I gather.
Correct, he didn't appear at all.
Okay, if he went to the orientation, we would have found out what he might have could have been doing, right?
Possibly, yes.
But we don't know that, do we?
Correct.
All right, so if the job turned out to be make work, is the decision going to be the same?
When you say made work?
Make work, like they're creating something that doesn't really exist. I don't even understand why the respondent wants this, be that as it may. But what if, see, I would have had my client show up at the orientation, because I think that's a key fact.
Well, once
So
again,
what's going on here?
Let's not argue with Andrew about how
I'm
he handled
not.
the case.
I'm just saying.
I don't think that's fair to you.
There's no good approach when you're on the ground making decisions on a case. I'm not criticizing.
Well, with respect to your comment about
I'd like to know what it was.
Made work, I think he was supposed to be like folding clothes or something like that, or storing stuff.
We don't know that, but it was kind of creation, for lack of a better term, of something that they didn't really have or did within their company. They're going to create this for this petitioner to go in there because this other company that Ina works for said, hey, I can get you a guy for nothing.
Okay.
So
I'm missing your point.
The point is that if he shows up at the orientation and you gather the, and hypothetically as an alternative approach, in addition to all those things, you say, why do I got to do this? They don't even have a job at this company normally that does this.
Okay,
I don't think that necessarily would lead to the same decision.
But conversely, Neil, if you are working for Relodyne and they put you in a room and you have to count widgets because you're on light duty, can your client refuse that?
No. No.
So what's the difference if they made up the job and
I have to
had to
say, I'm not, as a petitioner's lawyer, I might separate myself from some of my colleagues, but I'm not horribly offended by this concept. It doesn't bother me. But if it turns out to be nonsense, and my guy tries it, or he goes and finds out, then I'm going to have a problem with that.
I think if the facts came out, then the decision could be different.
We don't know.
We don't know. All the way back.
Yeah, you analogized your position to...
Oh, okay. I didn't see you, but go ahead, Martha.
You analogized your position to a loan borrow.
I said that was one of the ways I looked at it, yes.
Okay. I've got this situation going on right now where my client went to a charity at the behest of her employer for TTE and got injured.
Okay.
Now, under your theory, she should be able to sue the charity. They're saying, no, she's not an employee. And the employer is saying, no, she wasn't working for us, which is one of the problems with this concept. So I've got a client now who, in theory, may not have a right of recovery because both parties are saying, oh, no, she wasn't working for us.
Well, I mean, Martha, I think that situation's a little different because I think the facts of our case, they indicated he was our employee. They said Mr. Stagen was always going to remain the respondent's employee. So with your situation, I don't know how it went back and forth, but to, after the fact, turn around and say, well, he wasn't our employee, as a defense counsel, I think it's completely wrong. Well,
but that's exactly the kind of situation that Chuck was talking about before, in my opinion, when you said, well, what's the fear? There it is, guys. That's one of them.
Whether he's an employee or not, if someone's an employee and driving to an IME, they don't get compensated for the injury under the Act. So just because he's an employee.
So Andrew brings up a really great point here, right? So if Mr. Stagen remained an employee of Relodyne, right, and he gets hurt on a light-duty job that he's been assigned by Relodyne, Relodyne's responsible under the Workers' Compensation Act for that. So what that he was working off-site, right? He's still
David, I would tend to agree with you. I'm just telling you,
arising out of it in the course of it.
This makes it more
Andrew brings
complicated.
up a really great point, right? Has Relodyne converted him into a traveling employee, right? Right? Because they're saying your light duty is no longer at your place of employment. Your light duty is off premises somewhere. Have they converted him into, I think one of the legitimate questions about a situation like this is, have they converted him into a traveling employee because they are assigning him a job off-site, right? So, Amy, go ahead. You had a question.
That was actually my comment. I wanted to know if Jason thought he was a traveling employee.
I don't remember what the distance was, but I don't really, haven't really thought of it.
It doesn't matter. It's off-site.
Oh, nice. I can't hear all of you, and I'm trying to respond to the young lady's question.
Yeah, again, staying on topic, so if he's a traveling employee, I mean, most of us are at some point in our days traveling employees, I get paid mileage. Were you prepared and was the respondent prepared to pay him travel mileage and off-site meals the way the rest of us would get if we left our home work zone?
I think we're getting off the point here a little.
No, I'm asking, what were you prepared
just because
to pay?
we're looking at what could happen in the future in every possible scenario, and that's not the facts of the case.
Not every traveling employee is entitled to mileage or lunch money, right? But what they are entitled to is coverage under the Act, right? That's what I'm talking about. I'm not talking about those other things. An interesting question that this also brings up is, if he gets hurt working for Habitat, can Habitat assert exclusive remedy protection, right? So here's an interesting question. What if he slips and falls on water at Habitat? Can Habitat assert exclusive remedy protection? Is he, like Jason says, a borrowed employee for Habitat's purposes, or can Mr. Stagen say, you know what, I'm suing you, Habitat, in a civil negligence case because you're not my employer. My employer remains Relodyne, right? I'm just here because they told me this is where my job is today, just like they could tell me your job's out in the field, standing there guarding the field, right? Guarding the pile of salt as some of our employers.
I've been neglecting this side. David Barish had a question.
Well, Jason, you asked what was scary. What was scary is what this case is absolutely not about.
Okay.
This is not a cannabis case. And I think all my petitions run to need to understand that this is not a case where the person has maximum medical improvement. This is not a case where they made up a job intentionally to suppress the wage loss. If it was, it would be a revolution. What this is exactly what you said, a light-duty job. So it's not so scary in that sense. We do have some of the other issues that people have raised, but the big concern, for example, I think that Rich was getting at,
sent back to Catalyst. And for my friends on the respondent side, if you think that you're going to argue that this case means the Catalyst is alive, you got another thing coming. It's not even close to true.
And I would completely agree with you because as I indicated and as I argued with Rich, I think this is before MMI. I think the conversation changes completely because this is a light duty and a TTD issue.
It goes back to, is it reasonable light duty? We all know that if your client is given a job on a third shift, they got a deal. So if it's reasonable, I'm telling my client that my client has to deal with this. And because it's a temporary job. It is not a permanent job.
I haven't dealt with this a lot, so I'm not an expert by any means on this, transitional employment issue. But one thing that Dina Schneider did testify to, and whether you believe it or not, she's put out there that anybody that's off work for greater than 6 months in a row has a 50% less chance of ever going back to work in a full-duty capacity again. And I think that's benefits for everybody.
I mean, we can ask about the intention of the respondent, and I think that's a legitimate question, but I don't think that's a legal issue. If Jay Ridge is in the room, he can tell us about the Ford light duty group. And we can ask ourselves, which is worse? This or that?
Well, I think with the light duty, that was something the commission had brought up, but that wasn't what was argued at the time of trial. This was a transitional work program. The letter states that, and the question was, did petitioner have to do this transitional work? Did he have to do TTE? And that was the argument at trial. We agreed what the restrictions were.
I would agree with you completely, but just because, like I said, I go back to the fact that I don't know the word temporary transitional employment. I don't know where, but just because it's on the letter, it doesn't mean anything. You can call it whatever you want. I think the commission determined it was light duty, and that's what I believe it was. Over there.
There's one sentence don't negative.
I don't have it in front of me, so if you help me out.
Yeah, petitioner does not claim that his condition has not the safe support.
Okay, point.
Are they saying they think you said on the letter?
I don't believe so, no.
But how do you reconcile that double negative?
Yeah, I'm not sure you want, I'm not sure the person to answer that, but I think the facts indicated, and it was stipulated that he had restrictions and restrictions without MMI, so. I mean, I don't know if it's a typo or what.
Yeah, sorry about that, but how much, Andrew, how much do you plan on focusing on, like I said, the kind of the employer-employee relationship, the formation of that? In other words, like the example I was giving you, union members, many of them want to work in union shops. They believe it. Okay, you have someone go work outside of that. Now I understand the facts here where Jason's saying, we're going to pay you all your union benefits. You are doing union work, I guess is what they would say. But that's defined by the collective bargaining agreement, what union work is, what unit work is, and what isn't union work. I mean, how much of that do you think is the focus of your argument going forward?
That's going to be focused on going forward. We're going to focus on that because we don't, in reading the commission decision, I believe they thought this was a white job and that had to be addressed along with the transitional employment.
Yeah, just point out, this is why it was treating for the respondent's human resources and attendant policy. So if the respondent is a union employer, and that union employer has a 90-day limit on their light duty, this job offer was premised based on subject to respondent's human resources.
Sure, and I guess all I was saying, Dave, is every collective bargaining agreement defines the work that it controls, okay? If that work is not the same as the work in the collective bargaining agreement, then it is not.
Then it couldn't meet with that critical factor being subject to respondent's human resources policies.
As a petitioner's attorney, how do I get respondents' HR policies? I can't subpoena them from you, so how am I supposed to know what those policies are to back up my client in this kind of fight? I've got no access to that kind of stuff. Maybe.
Maybe not.
Maybe not. I mean, I have people who yeah, we're all supposed to be able to get the personnel records under the Personnel Records Review Act, but I have respondents tell me no, and respondents' attorneys tell me no discovery. So how would I be able to
George,
enforce
that's a
this?
matter of argument. That's a matter of the respondent not complying with something. That's not a matter of what this case stands for.
Respondents stipulated to it in this case.
Okay,
They
well-
stipulated to that he was subject to their policies, right?
Yeah, but
If they're violating their own policies, how do you ever find that out?
But how do I ever find out the policies? You know, I have no ability to find that. I'm thinking of it in terms of actual practice, not theory.
Well, this case here, we didn't get to what the policies might be violated
Yeah.
because the position was not accepted.
Yeah.
Any other questions?
Yeah. Why are you taking this case up at all? If the guy got his full salary and he's back to work doing his regular job, why take it up? Why not wait for the correct case where the employer is not paying full salary and where your circumstances are that they cover everything and they're paying full salary? Pick a case where they're paying TTV or fighting it. Why not take that case up? This is the wrong case to take up. Look at the facts.
I've heard different opinions on that, and I think this is important to take up to get clarification on the issue.
So you can make the bad case law on the wrong facts.
All right.
Hey.
That's Monday morning. Let him try his own case.
Really? Then you're going to deal with it later on. But
Yeah.
congratulations.
Maybe I can ask you for credit back, so
Yes, they are.
that's gonna go into your client's pocket, right?
If anybody has any other questions, I'll be happy to stick around and answer anything
All right,
anybody has.
thanks.
Thank you.